Let's go back to the prosecutor's memorandum, that you may need to cooperate with the prosecution. And if your CFO says to you, I did X, you may very well want to be able to disclose to the U.S. Attorney, my CFO did X. And the CFO should not be placed in a situation in which he believes or she believes that when he tells you X, that it's privileged. That's going to create a lot of problems. So that you have to ensure, and you must ensure, that employees or officers who are communicating with the corporation attorneys are on notice, that no attorney-client privilege exists between them, and that any information disclosed to the corporate attorneys can be disclosed to third parties if such disclosures serve the best interest of the corporation. The way to do it is you get your team together. I'm representing the corporation, you're representing the vice president, you're representing the CFO. We get together, we have a joint defense agreement, and then we discuss matters which are privileged. Now, this is a redacted version of the search warrant that was executed on my client. If you take a look at all of the attachment B, you're going to see what it is that was searched for. And then the next day, we received a grand jury subpoena, like I told you that they normally do, in order to have you, the onus is on you now, to produce the evidence that they want. But if you compare the two, you'll see that in addition to what was requested or on the search warrant, they now are asking for records of expense accounts and minutes and meetings. Well, what do you think precipitated that change? What precipitated the change was that before I got a call from the president that said the FBI is here executing search warrants, he spoke with the FBI and he gave an interview. And he discussed with them certain things and certain questions he had with respect to certain matters, including expense accounts that he had issues with and board of directors meetings that took place that he was concerned about. Like I said, the FBI, they're not dummies. And they understood that this was new information that they had prior to the investigation and prior to the execution of search warrants, so that the grand jury subpoena that was issued was expanded to include those things. Now, I'll tell you what happened in the case. I spoke with the U.S. Attorney. She told me that they were interested in these wire frauds. We got an extremely talented team of defense attorneys together, and we got an extremely talented forensic accountant to be able to take a look and see whether or not there was evidence of bank fraud through our own internal investigation. And you know what we learned? Remember I told you, you know, it's not going to happen to me. And the chairman of the board out in Chicago, the president of the company, you know, we run a clean company. We don't do this kind of thing. If there's evidence or if people are saying that there is a problem, it's just not true. What we learned was this. We learned that over the past 10 years, the CFO had embezzled $12.7 million. That he had 2 houses in Key West. The most amazing thing was that, remember I said that, you know, after a while I was even talking to clerical people. Who likes wine? Who knows what a Chateau d'Yquem is? Chateau d'Yquem is a very, very expensive wine. A half a bottle goes for $500. He was buying cases of wine that was being delivered to the corporation for his wine cellar. He had a wine cellar of his own at Peter Luger's Steakhouse in Brooklyn. He had, for a Christmas party, used the corporate assets to limo people up to Vermont for a ski week. The type of embezzlement that we were able to uncover was absolutely incredible. And when the crash came in 2008, and the violation, and you don't have as many recounts receivable, right? 2008, everybody's hurting. So the company is now below the minimum that they have to have in order to continue their line of credit. So the CFO decides to change the way in which that minimum is calculated. And he tells the clerical assistant, do it this way now. And doesn't tell the clerical assistant why she has to do it this way now. And the clerical assistant took this information to the FBI, which started the investigation. And the reason why he had to change, what's the big deal? Okay, everybody's hurting in 2008, right? Everybody's hurting. What would happen would be that if the reports to the credit line, to GE Capital, were below a certain point, it was going to trigger an audit. And if there was an audit, the embezzlement would have been uncovered. And that was the impetus of the investigation that ended up with the search warrant at the corporate headquarters. And what we did was, now I've got a whole team of lawyers, right, working with me, but they're now representing the bad guys. One of them is representing the CFO. One of them is representing somebody else who was involved in the scheme. Somebody else is representing somebody else. They're now my adversaries. I had to cut them loose and go to the U.S. Attorney's Office basically saying, I've just made your case for an embezzlement case. Your bank fraud case is going to be a mess, because all of these people are going to legitimize and tell you why the changes made were absolutely appropriate under certain accounting principles. But don't you want a sexy case? Here's an embezzlement of millions of dollars. My client is the victim. The shareholders are going to be a victim. The pension holders are going to be a victim. And what happened was, I was able to, after a year and a half, get a letter from the U.S. Attorney that said, your client is no longer a target of a criminal investigation. I felt great. I actually got a bottle of that wine. I personally felt very, very good for the chairman that was out in Chicago, for the president who was, absolutely devastated. But that's a hard thing to do. And I would have wished that the president did not talk to the FBI during the course of the search warrant. But ultimately, the investigation that we conducted ended up in the CFO going to federal penitentiary between 4 and 5 years. That the person who came to see me, that was who was asked to be interviewed that early morning, ended up going to prison for 2 years, and 2 other people ended up going to prison for 2 years. But the corporation was not indicted, and the corporation, who was my client, is the one that came out, while not completely unscathed, because, as you can tell, the agita was incredible. Imagine your client being indicted, corporate client. But the fact of the matter is that, like I said, when I do civil litigation for them, I don't get the responses that I get when we're dealing with something like that. And you as corporate counsel, you should be aware of the intricacies. And don't think that because I work for a corporation that is blue collar, white collar, which is one, probably, and I saw the list of where you guys are from, some of the finest corporations in the world, doesn't get you out of the vision and the microscope that the U.S. Attorney's Office and the Justice Department might provide simply because the secretary thinks that something is going on that's wrong. So I've gone over my time for about 5 minutes. I think that I have a little bit of time for questions, and I'll be here all day. I don't know if everybody could hear. The question is with respect to corporate Miranda, who is obliged to give the warning, and when does that kind of come into effect? Let me start with the first part. It comes into effect when you have reason to believe that there is an investigation that's being conducted that might impact the conflict of interest. The corporate Miranda should be given by the attorney that represents the corporation. That's my recommendation. And like I said earlier in the presentation, you need to determine whether or not you are the person who should be doing this. Not because you're not capable of it, but because it very well may be, as in-house corporate counsel, you may have knowledge concerning the facts which best serves your corporate entity as a witness, not as an advocate. The question is this: if you're a corporate counsel and a witness, do you risk the waiver, or how does that impact the attorney-client privilege? That's something that has to be discussed strategically with the lawyers that are representing the corporate entity and the corporate entity, which is your client. You have to make a judgment as to whether or not you want to waive an attorney-client privilege and under what circumstances. You know, the attorney-client privilege is important, but there are things that may have been said to you that you do not want to disclose. And oftentimes, and that's a whole different, I mean, we'll stand here for a half hour to talk about whether or not you can waive part of it or whether that waives all of it. But you got to make that determination as to whether that's more important than the ultimate verdict in the case or the ultimate decision that the U.S. Attorney's Office is going to make with respect to prosecution altogether. You know, you got to see what it is that is potentially going to be disclosed, because you certainly don't want to waive your attorney-client privilege in the theft of $500 and disclose information that leads you to get into an SEC violation that's going to screw you for a long time. I'll be here all day, but thank you very much. I really appreciate it.